Good day and welcome to Obidati Family TV, the program that Hope Alive. Yes, Hope Day. And I know say our principal is Excellency P2B. They always tell us say the miracle will happen for Anambra State. That same miracle will happen again. With that very one, we they bring on a better program today. We be say we go deliberate many things. So we say concern this very judgment. We be say we dey wait for the election petition tribunal make them for bring come. This judgment they very very important to Nigerians in general, even home and abroad. This judgment people don't they ask now which time they not even they tag Justice Tsammani. We be say where which date everybody they ask. This judgment they very important because now that judgment now it go help or it go mad the democracy will be say we did. So with that very one, we they bring plenty other things like Haruna Tsammani, the wife will be Lydia Haruna Tsammani. She don't get they don't confirm her as commissioner for Bauchi State. Now some people they ask plenty questions. Would the day will be say she go for this very hearing for the state assembly? The question be say, is they right? Will be say Justice Tsammani they preside over presidential election tribunal, and she they go take appointment where they come out from government. Whether it they right? For us when they here, the first thing we go tell and say, now congratulations as she don't get work. Maybe work no day before and I work on day now. So the people will be saying and say she no supposed to take the job. Well, now it depends on the moral, because why didn't they talk like this? Now because of say some justices no suppose they join issues with ordinary things or parties and other things like that. But all the same other one go join for the talk where we say we go talk inside studio today. Another one where they come out where they very very important, more than important. Now the one of the Court of Appeals where we say they for Lagos. This Court of Appeals where we say they for Lagos. Now the same category of the justices where they there. Now them be the same justices where they for the appeal court where we say then they handle this presidential election tribunal. Plenty matter they inside, but we reach out to the people where we say then they for Court of Appeals headquarters where they for Abuja, where this very particular presidential election judgment they expect make it come out from. And the people when they talk for there then tell me say we not get anything to worry, even as a concern that very judgment where they come out from Lagos appeal court. We go discuss them today. The implication where they with that very particular appeal court judgment for Lagos. Wetin it mean as far as INEC powers they because too much power where they give INEC don't begin to affect them. Then talk say the every result where we say they come out from INEC, then they adjudge them say it they correct. But then it get procedures where we say INEC no they follow, and it go void that particular result where they assume say it they correct. All this one we go discuss them inside here. And the people where we say then they talk from the headquarters of Court of Appeal, then talk say Justice Tsammani don't give assurance say death go come out very soon. And again say they know they look up not be about the result where INEC declare and then they look at the justice waiting happen for that very day, the process, the procedure, and all of those things. Now all that one all of us go discuss today. With that very one, I look at the Court of Appeals issue for Lagos Division, which has turned the Federal High Court where we say they overturn the matter where they first of all affirm about the electronically uploading the result of governorship and state assembly election directed to be viewed, to be sent to the result viewing portal, that is the IREV. And I know say the panel of judges will be saying that Justice Abubakar Omar, Justice Olukayode Bada, and Justice Onyekachi OTC. Then declare say INEC possess a significant discretionary authority to determine the mode of transmitting election results. Now, so that very Court of Appeal then take talk. The panel's judgment, where we say it dates July 19, they labeled the case brought forth by the Labour Party, that is for that very lower court, as an improper utilization of legal procedures. Now, all satisfied with this decision, the APC, where we say All Progressive Congress and Social Democratic Party, SDP, then go waka, seek permission to appeal the judgment. Eventually, they submitted their notice of appeal as parties to the matter. As they come do them, then the APC, represented by Wolo Olanipeku and their legal team, they contend for that lower court judgment, say it is very wrong, as they mandate INEC to transmit election results electronically. As the Electoral Act and associated regulations grant INEC the discretion to determine the method of result transmission, including manual options. Now, all these ones we go talk because that manual, now in the cause kata. The panel held that the provisions of the Electoral Act 2022 and its discretionary clauses give INEC the authority to decide the means of result transmission. Now, the court highlighted that Justice Lifu's reliance on Clause 37 and 38 of INEC regulations and guidelines was overridden by the flexibility granted to INEC by the Electoral Act itself. The appellate court emphasized that the power to establish regulations also involves the power to amend or alter them when necessary. Now, so appeal courts waiting for Lagos take conclude for that very case and then talk say now INEC get the whole power. Now INEC go decide. Now INEC regulations, whether manual or electronic, all that one now we go discuss today because plenty things so we say it they go wrong day. And that very decision now we they expect say Justice Tsammani go look and well say that decision when they talk about INEC is still no day correct. But we go discussion. The people were there for studio to discuss all of this thing with me, Angel there and Esther there.
Welcome, obedient and well-meaning Nigerians worldwide. Now, welcome back again to the show, Hope Alive, on top Obidati Family Television. You get plenty gist where we carry comes to them. Most importantly, wait till I go hear our PO as in take talk am. But my people, Mona, see, keep our eyes on the judiciary because a new and a better Nigeria, it don't they come.
Welcome, my well-meaning Nigeria. Good day, obedient worldwide. Welcome. Tell your neighbor, say, hope day. Yes, make all eyes day on judiciary. As they don't reward the wife of Justice Tsammani, make our eyes day. Make it no be say, na compensation they won't do. All eyes on judiciary. Come on board. Let's discuss.
Yes, make we discuss. And the discussion, we go start the very discussion with this very appeal court matter for Lagos. This very appeal court matter, why they bother us or they bother me and all of us will be say we dey here be say, now the same standard of, now the same level, this appeal justice is there with them panel, where we say then they do this very presidential election petition. But you get the thing, then they talk say discretion there on INEC to decide whether na electronic or na manual, na they won't do. And then come talk say that very low court, the Federal High Court where they for Lagos, where talk say INEC must do electronic transmission. Then talk say then they're wrong. Now the thing where we want talk because now the major process where we challenge for this very presidential election. Now, one of the things where I want make on a note where we say I don't study well overnight, make on a pay attention, make on a for understand where they come from. First, INEC then talk now then get the right to prescribe waiting then go use. And for this very particular 2023 election, then prescribe talk say now electronic and manual and they go use. Now, you get something where we say Sir Thomas Jefferson in the Council of Dangers of Trusting Man with Absolute Power. He get what he talk. He say that very thing they like say they very instructive for waiting we want talk here. Now Sir Thomas Jefferson talk say in question of power, let no more be had of confidence in man, but bind him down from mischief by the chains of the Constitution. Now, we have bound INEC by the chains of the Constitution, which is the law. We have bound them by the Electoral Act. And the Electoral Act, they're very, very clear on what INEC supposed to do. Make I take on this very journey, very short one, make on for understand. Say that very court, with that appeal court, it gets some things where we say they miss. That's although section 60 subsection 5 confers on the INEC powers to determine or prescribe the manner of collation of election results, which INEC has done in the regulations and guidelines for conduct of elections. Now, that is in 2022, where we say we just passed. It appears that the lawmaker did not want to leave anything to chance. Considering the main purpose of the annulment of the Electoral Act 2010, it gets something where we say it happened for 2010, where we 2010 Electoral Act, where we no one use them again. Now, electronic transmission and the introduction of innovative Electoral Act of 2022. It was introduced and integrated into it a real-time electronic transmission of election results as an indispensable part of the election result collation process. Election result collation process. Now, with the primary aim of preventing or reducing allegations of incidents of result manipulations that had marred the manual collation process, which was the sole method of collation under the old legal regime. Now, it is therefore not surprising that the lawmaker had proceeded to make special and specific provisions, as is seen in this section 47.3, subsection 64.4 to 8, and others of that very Electoral Act, to leave no one in doubt that INEC has no choice than to ensure mandatory real-time electronic transmission of election results. Now, a summary of election result collation procedure in section 64, subsection 4 to 8 is that 1. Collation of results by the collation or returning officer must be done using the electronic transmitted results and the manually collated results and the correctness and otherwise of the manual. Of the manual version must be determined by comparing it with the electronically transmitted version. 2. During collation, any dispute over results must be solved using both the electronic transmitted version and the manual version. 3. In cases of conflict between manual version and the e-transmitted version, the latter must prevail. 4. In case conflict of disputed result during collation, the collation officer may only announce the result after satisfactory resolution of the conflict disputes using the information in section 64 subsection 6, which must include the electronic transmitted result. 5. It could be thus seen that without the provision of clause 38 of the regulations and guidelines, section 64 of the Act has made existence of the electronic transmitted version of the result as an indispensable part of the collation process and the collation dispute resolving process. This takes precedence over anything to the contrary. In clause 48C of 90 or 93 of the regulations and guidelines, to the extent of such inconsistency. Then, further on the necessity of the e-transmitted result, electronic transmission of polling unit result to INEC collation system is supposed to ensure that INEC has copies of election results from the lowest level of election, that is the polling units, so that in that event, the inconsistencies in results or where they are tampered with in the process of physical collation, INEC can have recourse to electronically transmitted results in its collation system. That means the IREC portal allows the general public to view election results from various polling units as they are uploaded. Now, that is what the guidelines and the act have. The intentions are very, very clear. We migrated from the 2010 Electoral Act, which is purely manual, and we went to the 2022 Electoral Act, that the integral part of it is all about electronic transmission. The lawmakers made it very clear that electronic transmission is mandatory. Now, when I cite the case of the Court of Appeals in Lagos, saying that that there is no need for us to, or probably the lower court, to prescribe to INEC what mode they are to use. The mode they are to use is already prescribed by the Act itself, and they are bound by the law. INEC was bound by the law to obey what is written on the Act. Now, that very judgment that is given from the lower court is simply affirming what the Act has said, what the law has said. Now, the Court of Appeals coming to say they, INEC, can only decide what mode. They have already decided the mode. They have already told Nigerians what mode they are going to use. They told us both in their manual, they told us in their regulations, they told us on TV and internationally that they are going to do an e-transmission and they are going to do a manual collation, using e-transmission to pinpoint and weigh the options. They had never said at any point that what they are going to use is manual. Anyway, I want to make that clear so that our people will understand as we await the judgment of this very court. We want to hope that they look at this very well to know that INEC really prescribed e-transmission, and the whole Nigerians were informed about e-transmission and collation of results and no other. And that